Previously on Ready to Die.
All right, Mr. Short.
Your Honor, what just happened was completely dishonest, disingenuous, misleading, and gross.
I know it's not too ghetto. I know it's not too ghetto. I said I know it's not too ghetto. You better check yourself, respect yourself. You better go for self because I flow for self.
All right, Mr. Short.
Your Honor, what just happened was completely dishonest, disingenuous, misleading, and gross.
And
I objected, and I wouldn't have even thought about anyone doing this other than the fact that I've seen the prior behavior throughout this trial of this type of nonsense where we try to trick a witness into.
I want to see that warrant.
What?
I want to see that goddamn warrant.
There you go. Let's go.
You're saying they, meaning three people, and then try to convince the jury that we're somehow including my client Shannon when it's clear that the witness is not following. That's what we're talking about, and it's disgusting. And I don't know how we cure it, but I'm going to move for a mistrial.
My nigga.
I think it was completely intentional. Obviously, it was calculated. Obviously, when I asked for clarification, I would think anyone seeking the truth would gladly clarify. I'm seeking the truth.
Truth! You can't handle the truth!
No, it's sheepish grin and then.
All right, I understand your objection, and I understand what you were saying past that objection. Miss Love, I think one thing that... No, you need to listen.
No. No. Mm-mm. Mm-mm. No. 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 Hell no. No.
I think that one thing that needs to happen is when an objection is made and you are given an opportunity to respond and I make a ruling, even if that ruling is please clarify, that you then need to obey what my order is instead of continuing to argue.
Your Honor, when I ask for clarification and consideration, I believe that as an advocate and as a person who is actually representing the victims who have been victimized in this case and who is representing as much as actually more than an officer of this court, and I represent something, I believe that the state has as much right to express, to request, and to ask for consideration and for an allowance to ask the questions that it wishes to ask as the defense does. I believe, Your Honor, the objection that was made, and I understand what Mr. Shart said, but there are a couple of things at play here. One, Mr. Shart is well aware that Mr. Zachary has said that his client was with him. He has said it in the interview that I'm holding in my hand. He is not being honest with the court when he is claiming that Mr. Zachary had no idea what I was talking about. I literally said Shannon, Demikian, and Muktum, and I asked him how close he was with each of them.
Right. And then we went from that to his girlfriend, and then it was not unreasonable. And the objection could just be, vague, but it was not unreasonable to object to make sure that it was clear what the question was, who the they was in the question. And when I say clarify, that needs to be the end of it. And you need to ask a different question, rephrase the question, and let's move on. And there shouldn't be an issue with it.
Yes, Your Honor. If the state is not allowed to ask for clarification or consideration, that I understand.
I don't know what you mean by that.
Your Honor, when I
ask... A clarification of my ruling? Is that what you mean?
When I ask for permission beyond what the court has instructed, I did not know that I should not do that, so I won't do that anymore.
You got her trained, nigga.
You lead a whole water player, but you can't make her think. You dig what I'm saying?
That's not what was going on. You're basically, it seems to say, I'm asking permission to do something other than what the court has just ordered me to do. And so if that's what it is, then no, you cannot do that. If you need clarification of a ruling, then of course you can ask that.
Unlearn that bullshit they teach you at the academy, though. Don't bring none of that shit in here. Shit'll get you killed out here.
And if you want reconsideration, then you can ask for that, but that does not need to go on in front of the jury. When I make a ruling, obey the ruling and move on.
Yes, Your Honor.
Okay.
Your Honor, I really haven't heard any explanation for what happened. I think it was calculated. I'm moving for a mistrial. In the alternative, Your Honor, I do believe that there needs to be a curative instruction, or at least it needs to be clarified who they was. It doesn't matter what he said in the past. He lied in the past. I've already said that. I know what he said in the past.
All right.
But what he's
We don't know. You don't know that he lied. You don't know what the truth is and what the lie is if they are inconsistent. And there may even be a reason for that. Although if they're virtually diametrically opposed, there probably is not an explanation. But when you say he lied, we don't know that.
Okay.
Just like Miss Love doesn't know when he lied.
Well, I'll put it like this. Mr. Stillwell was never charged with those crimes. And Miss Love was not asking about what he said in 2015. She was asking about today.
I understand.
And today, he was clearly responding, they meaning Mr. Garlington, and well, it's clear to me. I don't believe it's clear to the
Don't
jury.
talk while he's talking.
And I believe it needs to be clarified immediately because, of course, I will have an opportunity to cross, but I will probably not have an opportunity to cross for about 4 days. And I don't think we should be misleading the jury on direct.
All right, I'm going to look back at what the transcript says. Thank you. I mean, and Ms. Love, you may, given that there's now a motion for mistrial on the floor, in assertion that you did things purposefully, you may respond to that.
I vehemently object to the mistrial. I vehemently object to any mistrial, and I beg the court to look at the transcript and see what I said right before I asked him the people that I just mentioned. And I would ask that the court, I mean, if the court deems it appropriate that such language is gross and all of the disparaging remarks made by counsel for the defendants are appropriate, that's one thing. But I'd ask that the court limit that type of behavior, which is, you know, not becoming of officers of the court.
I agree with that. It is not becoming. All right, y'all can take a break if you want to. I'm going to take a look at this transcript. All right, and in terms, I have reviewed what the line of questioning was, and I do not think that there was anything nefarious and purposeful about trying to trick him into something other than what he'd been talking about. At the same time, I can see how it might have been, well, now, are you sure he knows that the people we were just asking about are the people that you're talking about him now, you know, coming to pick him up? So a valid objection, it remains sustained, but the motion for mistrial is denied. I am not giving any kind of instruction. You can just fix it by asking the next question. All right. Anything else on that?
Your Honor, just for the record. Okay.
Okay. And you use the mic too.
Yep. I understand. Yes, Your Honor. And I understand the court's ruling. I think that the use, all of a sudden, the use of they and those people instead of names, and then when asked for clarification, the refusal to do so, I think suggests that there was some calculation. But I understand the court's finding, but I would ask the court to instruct Ms. Love to clarify with the first question so everyone's on the same page, so there's not confusion amongst the jury, who he is referring to when he's talking about they in the car that night.
Yeah. Okay. Yes.
Your Honor, the state tender states 528 Yankee as evidence.
I would actually object to it if it's not in the exact.
If it's what?
I would actually object to it if it is not as he remembers it to be, if it's been altered or if it's not the same that he's viewed previously.
Okay. Well, it is admitted, subject to the understanding that the date isn't to be relied on because we can't see what the date is.
And I've also objected to any hearsay that may be contained within that document.
I don't know if I don't know what the exhibit is. So is that an issue I need to take up?
And ask you, are you able to see the date on the digital version?
I am.
Your Honor, state. There's 528.
Okay. So are you going to, it'll ultimately be, are you just going to make a better copy and substitute? All right. That's fine. Then it's admitted in full.
As we're pulling up 528 Yankee, would you tell the jury what significance you found in 528 Yankee towards your investigation?
Well, there was a phone number posted it was a public post, and there was a phone number that was, there was a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
Okay. And was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and has to be stricken.
Which part?
Part about who the number belongs to.
Sustained.
Okay. What did you do to determine whose account this was?
Well, I looked at the photos that were posted in the account, I believe. And I mean, traditionally, that's what I would do with an Instagram page. It's just posted in public view.
Okay. And what was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment and,
Posted by the owner or user of the account?
That was all speculation, not object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to?
I
What
would
handle
renew
the
my
number
objection,
is
also
next to?
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay, when
Your Honor,
we were up here at the bench.
so, Your Honor, I'll ask additional questions that I think will.
Sustained.
Okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Your Honor, so
Yeah.
well, first of all, my motion is a motion for mistrial, based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
may I respond?
You may.
Judge,
Can somebody put the document up?
yes. First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the comment? There it is.
Yeah.
Okay.
The comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number one of the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
it.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back. All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter before the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F 2nd 255. It's the 9th Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing: is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, Your Honor. It is all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree.
It's just constant hiding laws, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court. And I think that it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said for all these things is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
It's renewed.
Thank you.
Sergeant Gaither, do you recall during the time that you and Detective Dennis spoke with Quindaria Zachary, talking to him about the day Lucci's mother's house was shot, or one of the shootings at Lucci's mother's house?
Yes.
Before you spoke with Quindaria Zachary on August the 5th, 2015, did you have information, any other information, that Shannon had a 223 on that day before you spoke to Mr. Zachary?
No.
And before that, did you have any information about the type of gun Woody had at the time Miss Reed's house was shot up?
No.
And before you spoke to Mr. Zachary, did you have any other information about Pokey being involved in Lucci's mother's shooting?
No.
Throughout the interview with Mr. Zachary, did he provide you with what you would have considered incriminating information about Kenneth Copeland that you had not previously received from other sources?
Yes.
And what about Mr. Garlington? Did he give you information about Mr. Garlington that you had not received from other sources?
Yes.
Did he provide you with information regarding the January 10th, 2015 murder of Donovan Thomas and what happened before and after that you had not received from other sources?
Yes.
With respect to Antonio Sledge, did Mr. Zachary, during your August 5th, 2015 interview with Mr. Zachary, give you what you would have considered incriminating information about Antonio Sledge?
Yes.
Was that information known to you from any other source before you talked to Mr. Zachary on August the 5th?
Yes. Some of it, yes.
Was all of it?
Not all of it, no.
The information regarding Mr. Sledge shooting at Kel with Woody, was that known to you?
No.
And would you consider that incriminating information about Mr. Sledge?
Yes.
Did Mr. Sledge ever hint to you at any time during his interview with you that he had anything to do with shooting at a rival gang member?
No.
Did the information that Mr. Zachary gave you about Tay being a person that you knew to be affiliated with MDC, did I get that right or did I get
Yes.
that wrong? Did that cause you in any way to question or challenge what information you were being given by Mr. Zachary?
No.
Why not when MDC is a different group from YSL?
He provided information that some of it, which I already knew, would.
Your Honor, the assertion regarding it's not bolstering. It is an effort to show
I'm going to sustain and you can rephrase.
Okay. Why did Mr. Zachary's explanation regarding being from Capitol Homes, him being from Capitol Homes, Moot being from Capitol Homes, and Tay being from Capitol Homes have any significance to you?
Sustained. Yeah. She said, or he said, assumes facts, not in evidence.
During the interview, do you recall Mr. Zachary talking about himself being from Capitol Homes, Moot being from Capitol Homes, and a third person that belongs to another group being from Capitol Homes?
Yes.
What was that third person?
Tay.
So during the interview, did Mr. Zachary talk to you about him, Moot, and Tay all being from Capitol Homes?
He did.
Did that information have any significance to you?
It did.
What significance?
I showed a prior relationship
between
those three individuals.
Okay. Despite the fact that Tay was MDC and Mr. Zachary and Mr. Sledge were YSL?
Yes.
I'll withdraw it. Thank you. I'll withdraw. Why was the fact that those three people had a prior association of any interest in your investigation?
It showed their continued alliance, even though they were from different gangs and lived on different sides of town. Presently, it showed their prior relationship from their roots, which was Capitol Homes.
Did that information in any way help you corroborate or disprove the information you were getting from Mr. Zachary?
It made me believe it more. Cooperated.
Sustained.
So not talking about what you believed.
Okay.
Hang on just a second.
Move to strike.
That'll be stricken. Please disregard that last answer.
Did that information corroborate or disprove for you any of the other information that you got from, and Your Honor, my understanding is her belief is irrelevant, but corroboration towards her, what she considered corroboration is relevant and important. Because, okay, so
yes.
Did it, okay, thank you. Showing you 526 Yankee Juliet, or publishing for the jury. Is that location the one that you described as 151 Cleveland, the BP gas station?
Yes.
All right. Thank you. Now, did you go down to any rental agencies yourself to try and locate any rental vehicles that Mr. Zachary talked about Defendant Williams having during the time of Donovan Thomas's murder?
For
you yourself?
Not for the murder, no.
Was that something that Detective Thorpe was primarily responsible for, or was that?
Yes, that was his case. He was a primary.
Justin Cobb, before you heard the name Doo-Wop from Quindarius Zachary, did you know Justin Cobb to be affiliated with any gangs?
No.
And did you ever classify or get information that caused you to believe that he was or wasn't?
Confrontation clause.
Overruled.
I don't recall. I don't believe so.
Okay. Was Quindarius Zachary the first person that you learned of the name Justin Cobb from?
Yes.
Do not think